All right, please come forward at the matter at line 3, Move Eden Housing et al., petitioner and appellants versus the City of Livermore, respondents in Eden Housing, Inc., real parties in interest. Okay. Let's start with the petitioner appellants.
Good morning, Your Honor. Winston Stromberg on behalf of petitioners and appellants.
And
good morning, Your Honor. Peter Pierce on behalf of the respondents, City of Livermore, and the City Clerk of the City of Livermore.
very good.
Good morning. Robert Hall on behalf of Real Party Eden Housing. Thank you.
Hi. I am Justice Terry L. Jackson. I'm the presiding justice of this division. I am joined on this case by Justice Mark Simons and Justice Danny Chu. You received the tentative from the court, and in the tentative, it sets forth each side will be given 20 minutes. Also, it sets forth that the respondent will argue first. We have respondent as well as the real party in interest. How do you wish to divide or allot your time for your 20 minutes?
Your Honor,
there will be no rebuttal since you are the respondents. You understand?
Thank you, Your Honor. I will speak for 15 minutes, and Mr. Hull will speak for 5. Good morning, and may it please the court, Peter Pierce appearing on behalf of the City of Livermore and the City Clerk. The city submits on the tentative opinion as to whether the city was acting as the state's administrative agent. With respect to the legislative act issue, I'd like to make 2 points. The first is a factual point as to Veterans Park. The tentative observes that the record shows, and this is on page 10, that the 2022 agreement was the city's first formal policy determination with respect to the funding of Veterans Park. And the city understands why the court reached that conclusion based on the record. But we would ask the court to make a linguistic change to that provision, and I will explain why.
Counsel, just to clarify, so you're going to say, because of things that happened outside the record, some significant fact in the tentative is incorrect?
Yes, Your Honor.
Okay. You see the problem with that.
I do, and I was about to explain why the record does not include that information, and the reason the record does not include that information is as follows. There were earlier documents showing that funding had been allocated to the park before 2022, and they were not included in the record because that money was already appropriated. That was public knowledge, and nobody challenged it, including the petitioner, and the referendum at issue did not challenge those earlier funding items, so it didn't occur to me to include those in the record, for better or worse. And I've always seen this case really as a challenge to the housing component of the project, because the referendum itself defines project as the housing component. So that's the reason why, Your Honor, the information.
So are you saying the $5.5 million was additional money? What change are you wishing us to make based on facts outside the record?
I am asking the court just to make the linguistic change to clarify and to say on this record it appears that the first funding was in 2022. So going forward, if the issue of earlier funding becomes an issue in subsequent litigation, this project has been mired in litigation. I think it's foreseeable that there may be future litigation. I just don't want this opinion to read in a way that forecloses the opportunity in the future for evidence of the earlier funding to be introduced. That is what I am saying.
Okay,
and that's why I'm calling.
Let me ask you a different question, and that is relating to the park. How can we read the provisions, the provision relating to the park in the 2022 agreement as, how can we read that as administrative? Isn't it approving a project that had not been approved before, and which is, of course, a policy decision, and then allocated a substantial sum of money to pay for that project. That is, and the project is constructing improvements at the park. How can we, under the case law, given the combination of those two things, not find this to be legislative?
Your Honor, and I'm repeating what's in our brief, but we construed the First Amendment to the DDA as setting the policy that this park would be funded. And it is true that the 2022 agreement is the first indication that is in the record that sets that amount at 5.5
Well,
million.
you're talking about the 2021 agreement.
Yes, Your Honor. 2021
agreement, as I read it, said simply the city has an option
Yes, Your Honor.
to negotiate with Eden a future construction and reimbursement agreement. How can we, help me here, how can we find that option to negotiate as a policy that says, yes, there'll be a park with improvements?
Because it puts the possibility on the table, and that's the best answer that I can give you, Your Honor.
Okay, thanks.
Turning from the Veterans Park issue to the indemnity provision, the tentative opinion concludes that 2022 agreement is the first formal policy choice to expend substantial money on the indemnity provision. I conceptualize the indemnity provision a little differently. Anyone in the chain of title on the property is liable for the remediation of hazardous waste. And so when the city sold the property to Eden Housing, it wanted Eden to share in that liability. Accordingly, what the city was doing in the indemnity provision was capping its liability at $4.3 million in the event the city and Eden Housing are ever sued in a remediation action. Of course, it's speculative whether any lawsuit might ever be filed. But the key point here is that there was no appropriation of funds that are occasioned by limiting liability in the event of environmental litigation. So for that particular reason, we do not read the indemnity provision.
I apologize. If you want to finish your sentence.
Oh, I was just going to say, Justice Chu, we do not read the indemnity provision as being a legislative.
So if I understand your argument, is your argument that back when the 2018 DDLA was adopted, that it contemplated that the liability of the city could be unlimited with respect to the hazardous materials, but that it wanted to try to share it with Eden, and that at most what the 2022 DDLA did was actually simply cap what would have been unlimited liability at that time? And your argument is that's not a legislative act, that's simply an administrative act because it's actually reducing the scope of the liability potentially for the city for that hazardous waste.
Precisely, Your Honor. That's exactly our argument.
Okay, thank you.
I may move on to the remedy. I wanted to spend some time.
And actually, if I can
Yes, Your Honor.
Interrupt you briefly here. Obviously, in our tentative, in footnote 5, we declined to address whether the loan is a legislative act versus administrative act. Is there any reason in the city's view for us to reach that issue here?
Your Honor.
And if so, what is your, I assume your argument's going to be is that it's an administrative act rather than a legislative act.
Our argument is that it is an administrative act. It may be helpful to the parties going forward for this court to reach that issue, but I would preface that by saying that the court also could, in not reaching that issue, if it ever comes up again, if the council decides whether to either repeal the matter or to submit it to the voters, and the acquisition provision comes up again, the trial court in the first instance, with the guidance from this court's opinion, could decide that issue in the first instance. Because recall, the trial court decided this case under San Bruno. And this court has now said that was an incorrect analysis. So with the guidance and wisdom of this court's tentative opinion or its final opinion, the trial court could decide that issue. But you're right, Justice Chu, it is our position that that is an administrative issue, and that is fully set out in our briefing as to why. So I don't want to dissuade the court from deciding that issue if it chooses to, but it does not need to decide that issue. The trial court could decide that at a later time.
What about the same issue with respect to the hazardous materials? We've given two bases for why we found that this is a legislative act versus a administrative act. Arguably, we'd only need one. Is there a reason why the city thinks it would be a good idea for us to address both, or would it make sense for us, in the interest of judicial economy, not deciding more than we have to, just decide one?
I think the court in its discretion could just decide one issue. And that gets me to what I wanted to talk about actually in terms of the remedy. The tentative opinion directs the trial court to order the city to process the referendum petition. And as we know, the appellant has challenged 3 of the provisions. This court in its tentative opinion has found that 2 are legislative acts and declined to reach the 3rd issue. In light of the scope of the opinion, the city requests that instead of ordering the city to process the entire referendum petition, that this court refine the order such that the city may either repeal only the 2 provisions, or 1 provision as the case may end up being, which the court concludes are legislative, or alternatively that the city can submit only the invalid 2 provisions or 1 provision to the voter.
I guess your position raises an interesting question for me. Can you take a referendum as to a portion of a legislative act, or does the referendum have to be to the entire legislative act? Because here, as I understand it, the legislative act was the approval of the entire 2022 amended DDLA, and I thought that if you take a random referendum from a legislative act, it has to go to the entire act. Are you suggesting that you can actually do it to a portion of an act?
Yes, Your Honor. There's case authority on this. There's a case called Dye, D-Y-E, versus the Council of the City of Compton, and the citation is 80 Cal App 2nd 486. I notified my colleague on the other side on Tuesday night that I would be citing this case so he would be prepared to discuss it. The Dye case, in the Dye case, the court concluded that 1 or more provisions in a city ordinance, as opposed to the entire city ordinance, are subject to the referendum power. And there at issue was a licensed tax ordinance where 2 electors of the city chose to challenge only 2 of 6 or 7 amended provisions of the ordinance. The Court of Appeal observed that while the Elections Code appeared to authorize a referendum only as to the entire ordinance, the constitutional power of referendum possessed by electors extends to sections and parts of an ordinance and not only to the entire ordinance. Now, Dye was decided in 1947 when the Elections Code was differently organized, but those provisions that were at issue in Dye are the predecessor provisions to the issues of the Elections Code at issue here today, specifically Section 9241, which is the section, Justice Chu, I think you might have been referring to, that if the city does not entirely repeal the ordinance, it must submit the ordinance to the voters. But the Dye case provides authority for the court to order parts of an ordinance or resolution.
So and let me confess, I have not read Dye, so I don't know exactly what it says, but here the resolution is pretty short, right? It's basically a couple pages and basically saying we approve the 2022 DDLA. In order to adopt your position, do we have to conclude that the DDLA in its entirety is actually the ordinance rather than simply the resolution approving it? Is my argument making sense? Or my question making sense?
No,
rather?
I'm not understanding your question.
I guess the way I read the resolution here is it simply approve the 2022 DDLA in its entirety.
That's correct.
So there's no portion of the resolution that be construed as simply approving a portion of that DDLA. It seemed like an all or nothing thing. And your Dye decision suggests that there are different provisions in the ordinance that you could take a referendum to, but still maintain the other portion. I didn't see how this resolution could be divided in the manner that you're suggesting the Dye court did.
I was talking about dividing the DDLA itself, which is adopted through the resolution, not parsing the language of the one-page resolution, but lifting different provisions of the resolution. Specifically, since the appellants challenged only 3 discrete parts of it, in my view, the court can order a remedy that addresses only one or some of those parts under the Dye case.
Counsel, let me suggest that this case may be different than Dye in one other particular, though, of course, I also haven't read Dye. And that is, here, the petition for referendum attacked the whole, attacked not the whole ordinance, but attacked 3 different things. So we're not only parsing, you're not only asking us to parse the ordinance, but in effect to parse the referendum and only allow the referendum to go to the voters on 1 or 2 issues out of the 3 that were asked for, as opposed to saying, no, it can't go at all or whatever, or it goes in its entirety. You, of course, can repeal the ordinance and then perhaps reenact portions of it. But how can we, even if we could pick and choose among things in the ordinance, can we pick and choose among things in the referendum?
Yes, Your Honor, and that's because Section 9241, which I cited earlier, that really doesn't appear to contemplate a situation where there's been a challenge to an ordinance provision or to certain provisions, specific provisions of a city's ordinance or resolution, and a court has concluded that the challenge is meritorious as to some or most, but not all, or in this case, has reserved ruling for the future. The statute just doesn't contemplate that unique circumstance. And so that's why I think courts oftentimes are called upon to, this is why courts exist. What do we do when the statute doesn't tell us what to do? And what I'm saying here is, under the unique circumstances of this case, that Section 9241 doesn't act as an absolute statutory constraint to the court fashioning the more narrow relief that I'm advocating. And if I might come at it at one other angle as well.
Well, you asked for 15 minutes and you have used, and I realize we have asked questions. So
may I make one more request of the court?
all right.
And that is a language change in the opinion on page 7. The top of page 7, it mentions that the city clerk refused to process the referendum petition based on the city's conclusion that the resolution. We would ask that the court revise the language to say based on legal advice that the resolution was not subject to. That is the request of the city clerk.
Thank you.
Thank you so much.
Counsel, I believe you wanted to have 5 minutes. All right.
Good morning. I'm here to address the 529.2 bond. I would request that the court limit its holding or narrow its holding on this issue. If the court wishes to adopt its tentative or some version of its tentative that reverses on the underlying merits of the referendum claim, I would ask that it simply reverse the bond and not go further and make the determination that this action does not challenge a housing project. This is not the case or the record to make that determination, and it may unnecessarily limit the effectiveness of one of the few protections available to affordable housing projects. Section 529.2 is actually quite broad in its language. It says it applies to all civil actions challenging a housing project, and further applies if simply the bringing of the action or the seeking of certain relief prevents or delays the project. Now, the legislature has used other, more defined language in other contexts that it did not use here. For example, in Government Code 65009, which addresses the statute of limitations for bringing certain challenges. It says, in an action to attack, set aside, or void certain planning and zoning permits, that action shall be brought in 90 days. So if the legislature wanted to make 529.2 similarly limited to certain types of actions challenging specific decisions made by a city or a county, it could have done so here, but it did not, and it made the language very broad to all civil actions.
Counsel, sorry, go ahead.
Counsel, do you have any case authority that supports your interpretation of the bond statute?
So there's only, to my knowledge, one published case on this, and that's the Save Livermore downtown case, which involved both a planning and zoning and a CEQA challenge. It held that a CEQA challenge is subject to the bond, and my argument there is that CEQA is challenging a city's review, environmental review, and compliance with the environmental law, to ensure that adequate mitigation measures are included. It's not a challenge to a permit that is issued to a project. A CEQA document is not a permit, it's an environmental clearance document. Here, the appellants have claimed that this is brought to enforce the elections code. That in my view is no different than bringing out a challenge to enforce environmental protections. So I think you can read Save Livermore downtown as a broad application of Section 529.2 to expand beyond a direct challenge to a project permit. And I think particularly here, where the referendum, and as the court's tentative in fact recognizes, that the referendum challenges the project and would have the effect of delaying it. And an action seeking to enforce that very same referendum does the exact same thing.
Counsel, one of our reasons for concluding that there was no bond required here is that this was a lawsuit that plaintiffs or petitioners never should have had to file because the city clerk improperly rejected the referendum. How does that reasoning implicate your concern here, given that this was a lawsuit that frankly they never should have had to file?
Sure, I think, and I noted the hypo in the court's tentative, but I'm not sure it's particularly relevant actually, given that the court elsewhere in the tentative and in the cases it cites recognizes that pre-election review is permissible in some cases. And so taking this case all the way to...
Well, but the pre-election review under our tentative should have been filed by the city once the clerk processed the referendum in an action arguing that it shouldn't be placed on the ballot, which is quite a common occurrence. Well, common in the sense that you see those lawsuits filed with some frequency.
Sure, but I also think that there are court cases that have been cited that recognize a city doing this step before to further the administration of a legislative act that they've done in the past. And therefore, for example, if petitioners brought a referendum against approval of a design review permit, which we know clearly is not a legislative act, I think the city could rightfully look at that and say this is not subject to referendum and not put it on the ballot.
But wouldn't it have to file a lawsuit in order to do that? I mean, the city clerk has no discretion at that point not to say the referendum's on the ballot, and then it would be incumbent on the city to file that lawsuit to take it off the ballot in your hypothetical, wouldn't it?
I'm not sure that's necessarily true, and I believe some of the cases have proceeded in this type of procedural posture. I certainly know that the court's preference here would have been for the city to file the challenge rather than to reject it.
It seems to me that's the law's preference. I mean, and we can speculate on why the workaround the law was implemented, and I'm not being critical of that. That's fine. But that does seem to be the law's preference.
Sure. I don't think I'm changing your mind on that issue, though I do note that I believe the cases cited here have followed this procedural posture before, which means it could happen again. And I don't think that as a matter of law, the court needs to take those types of challenges off the table under 529.2.
We wouldn't be taking that, we would be taking the ability to get a bond
Correct.
off the table, not the ability to proceed in the way that you proceeded here.
Right, and I'm suggesting that the court doesn't need to take the 529.2 bond off the table in that circumstance, particularly under certain hypotheticals that it would be clearly challenging an administrative act, and there could be further evidence, right, that it was brought to delay an affordable housing project. And given the broad language of 529.2, I don't think this court has to make the matter of law determination that it does not apply in these types of cases.
All right, counsel, thank you very much.
Thank you very much.
All right. You have 20 minutes, no rebuttal, of course.
Good morning, Your Honors. Winston Stromberg on behalf of petitioners. I will not take 20 minutes. I want to address a few of the comments that were made, made by counsel for the city and for Real Party. First, I want to state that we concur with the court's tentative opinion and its determinations on all of the issues on appeal. I think the court got it right and did it thoroughly and appropriately under the law. With respect to the city's point about the park allocation and asking for some language to be added to the opinion that doesn't exist in the record, the city had every opportunity to bring evidence to the trial court to explain why the allocation of $5.5 million in the 2022 agreement was not a legislative act. They proffered their evidence. It's too late to come to this court and say, Your Honor, there was something else that we forgot to tell you before. So there's no need to address that point. On the indemnity agreement, correct, it caps liability at $4.3 million. This was not addressed in the prior agreement. The 2022 agreement caps that liability, but it will be money that the city is authorized to spend. It is dipping into the city's pocketbooks to spend this money in the event that these issues arise.
Didn't the other agreements just say you would have to spend, but there was no cap, so it could have been well above the $4 million?
The prior agreement simply said that the city and developer will enter into an agreement to apportion liability. That
Which could be more than $4 million, right?
Or it could be none. It could be, it was silent as to that issue.
So therefore, they just capped it. They just said, regardless, it's going to stop at $4 million.
Correct.
It could be zero. Oh, excuse me.
Sorry, go ahead.
It could be 0 to $4 million, but the bottom line is the city has less liability or less exposure, I should say.
Potentially, Your Honor, yes.
Can I clarify? As I read it, it appears that the 2018 and the 2022 discussions of remediation, the only difference between the two is that the 2022 sets out that amount, whether we call that an authorization or a ceiling. That's the only difference between those two agreements. Is that correct?
On the specificity of how liability is to be apportioned, correct. There are some other details in the 2022 agreement about how contamination will be handled, but as to the apportionment of liability, that is correct.
Okay. Good. And without paragraphs 5 and 6 in the 2018 agreement, we would have a situation where the city would have been subject to unlimited liability for hazardous waste. Isn't that correct?
Potentially. That could be correct. But that issue.
I mean, how could it not be correct? When I say unlimited, it may be it's only for issues that were not disclosed, for example. But in terms of the amount of liability, it would be unlimited, except for 5 and 6.
I will concede that point.
And so then, doesn't that help? Again, I'm getting back ultimately or eventually to Justice Jackson's point, and I think maybe Justice Chu's point, that what we then have is in 2022 a ceiling being put on the amount that's owed. and that's a proper way to view the remediation status.
I agree, Your Honor. I think the difference here is this is part of an agreement, a comprehensive agreement with the developer that allocates city funding overall, and it's just a piece of that pie.
And if we were to conclude that the assumptions and the questions that I asked you a moment ago, that those are in fact an accurate way to read the situation, would you agree that it would then be appropriate to find the remediation piece administrative?
I still don't believe that's administrative.
Why?
Because the city is agreeing with the developer that it will fund a certain amount of, provide funding for a certain amount of liability that may occur as a result of cleaning up the hazardous waste under the property. There is cleanup actions that are occurring right now, I believe, and the city is using its own funds to accomplish that goal.
But that's, if I understand it, isn't that a liability that the city would have regardless of who they entered into an agreement to develop the property for whatever purposes?
Typically, yes, under hazardous.
And I used to do circle cases, so I can tell you generally yes,
Yes,
but
that's-
at least based on my limited
Yes.
experience. But so aren't they not really giving up anything and in fact are gaining something by putting a cap? That is to the benefit of taxpayers, presumably?
Potentially, that's one way of looking at it. At the end of the day, Your Honors, all that is needed is one portion of this agreement to be legislative. And the court is correct that, at the very least, the $5.5 million allocation to fund a public park accessible to all of the community and all of the voters and the region is a legislative action. And that makes this entire resolution a legislative action. You can't parse it into pieces like my opposing counsel has said. And I actually want to address that Dye case that opposing counsel had mentioned. First of all, in Dye, the petitioners there specifically brought a referendum challenging just a couple sections of an ordinance. They weren't challenging the whole ordinance. They were saying repeal sections A, B, and C. It's not a remedy case. The case is about whether a petitioner of the voters of a city could actually come back to when a legislation was adopted and say we only want to challenge part of that legislation. And that's what that case stands for. It doesn't stand for the proposition that a petition that challenges an entire legislative action, which is what has happened here, can be rewritten as a remedy. The appropriate remedy here is exactly what the court wrote in the tentative opinion, to complete the processing of the referendum that the city clerk refused to do.
So, and I apologize, if I understand your argument is Dye stands for the proposition that the party who is bringing forth a referendum can dictate its scope.
Correct.
That the court and presumably the party, the government entity who is having their ordinance challenged can't dictate the scope of that referendum.
That's correct, Your Honor.
All right, thank you.
Given the city's ability to respond to the referendum by repealing the ordinance, do you see any advantage to this court clarifying not only its view on the park, but its view on the other two issues that you challenged in your briefing?
The more clarity, the better. We always like clarity from the court. So I don't see
I
any.
suppose it often depends on whose ox is gored by the clarity, but I'll take your word for it that you, for one, always appreciate clarity. Okay.
I do.
So you see an advantage in assisting the parties as they move along on this, if they choose to move along on this.
Absolutely. And Your Honor, I mean, assuming that the court's remedy holds, that the clerk is to go process this referendum, then it becomes a political process. There will be an election, and there will be opportunities for the proponents of the referendum to push their side in the political sphere for the election, and for the city and the real party to push their side, assuming that the city council does not repeal the resolution. So we need to move past this process and onto the political process, which is why my client is here in the first place, because they challenge the resolution. They want this brought to a vote of the people.
Do you think it's valid for us to take into account why your client is here? Is that an
Not
issue
at
you
all.
would like to get into?
I don't think so at all. I
didn't think so. Thanks.
Well, along the lines of your suggestion that it would help for clarity's sake, can you address the argument about why the loan provisions within the 2022 DDLA should be considered a legislative act rather than an administrative act?
Of course, I'm happy to do that. As we noted in our brief, that was the first indication of the actual amount of money that the city was going to loan Eden Housing to purchase the property and over a term of 55 years with a low interest rate.
Well, but wasn't the 55-year term already in the 2018 DDLA?
A low interest rate.
And the low interest rate was one of two options for the interest in the 2018, and the 22 DDLA simply made clear which option was going to be chosen. Is that correct?
That's correct.
Okay. So it's basically the amount.
Correct.
That's what's different between the 2022 DDLA and the 2018 DDLA.
That's correct.
Okay.
Last, I want to move on to the argument from Real Party about the bond. And for this point, let's look exactly about what this case is about, which the court addressed perfectly in the tentative. This is a challenge to the city clerk's failure to process a referendum and violation of her ministerial mandatory duties under the election law. This is not a challenge to a housing project. The statute itself, 529.2, states that the developer may seek an order requiring the plaintiff to furnish an undertaking in a civil action brought by any plaintiff to challenge a housing project. That's the plain language of the statute. Council mentioned, well, this is similar to CEQA. CEQA is expressly called out in the statute. If the legislature wanted this to apply to elections code provisions, challenge referendums and whatnot, that would have been spelled out in the statute. But the statute says a civil action brought by a plaintiff to challenge a housing project, and it defines a housing project as a development project under a section of the government code that applies to permits and how the permits are supposed to be processed by government agencies. We also completely agree with the court's position that the bond here essentially punishes the voters of Livermore for asking the court for relief because of the city clerk's failure to comply with her duties. So unless there's any other questions, I will be done.
I want to get back a little bit to the remediation issue. At least I thought I did, but it was such a good point, I promptly forgot it. As I was enthralled by your discussion on the bond. Let's say we have a situation where the city is involved in litigation over something, and the city settles the lawsuit and agrees to pay a certain amount of money. Is that a legislative act, or is that an administrative act?
The settlement of a lawsuit?
In other words, to bring it to the situation we have in our case, the city has a potential liability of unknown dimension for the hazardous waste. It therefore enters into different agreements, but ultimately makes an agreement that it will pay up to $4.5, I think it was, million in order to basically resolve the unknown and avoid greater liability. Is that itself a articulation of a policy such that it becomes an administrative act? Let's ignore my hypothetical because I don't want to get into lawsuits. But are you following my question?
Yeah, I am following your question. I think it depends on the situation. Certainly, when the settlement agreement will be approved in a closed session, and not before the public, and so I don't think any of what we're talking about here is anywhere related to settlement agreement.
Let's ignore that.
I don't think case law has addressed whether entering into a settlement agreement is a legislative act or an administrative act. It would seem to be more of an administrative act from my perspective, because it's certainly just resolving one issue between a city and a particular party, as opposed to making a policy pronunciation that is political in nature.
Why wouldn't we view what happened here as an administrative act? That is.
Are you speaking about the remediation provision?
Yes, exactly. It didn't make certain what the city would have to pay, but it put a cap on it. And, it may be that everybody will be lucky and there's $100,000 worth of work that needs to be done to solve the problem. Great. But if there's $10 million worth of work that needs to be done, the city has acted in a way to protect itself, let's say.
Sure.
So in that situation, doesn't that seem to be an administrative act, not a...
I think standing on its own, yes, but I think when you bundle it all together with the purpose of this agreement and the purpose that the cleanup of the contamination is to benefit the public as a whole, and the development of the park is to benefit the public as a whole, I think it's standing on its own. If my client had sought to referend an agreement that's simply the liability and apportionment, a standalone agreement that's not bundled together with all these other pieces, that would definitely be an administrative act.
What if the city took the DDLA and did it in a series of agreements? Let's suppose one agreement addressed the housing component, a separate agreement addressed the park, and a third agreement addressed this indemnity provision. Is your position that that third agreement dealing solely with the indemnity would no longer be a legislative act, it'd be an administrative act if it's parsed out in that way?
That particular, yes.
Okay, thank you.
All right. You said that you wanted to be under 20 minutes. You are.
Thank you.
By 1 minute. Thank you very much. All right, the matter is now submitted to the court. The court wishes to take this opportunity to thank the briefing in this case, as well as the arguments that we've heard this morning. Thank you very much. Okay.